Hello and welcome to the first webinar from the Silicon Valley team for 2022. And boy, do we have an exciting and dramatic topic to discuss today. So thank you very much for joining us. Just some quick housekeeping. We are aiming to cover lots of interesting discussion on the topic of the Austrian DPA's decision and generally talk about what's happening with European US data transfers in the wake of that decision and some other really interesting developments in that area over the next 30 minutes. And we're also going to leave some time for questions. So if you do have any burning questions at the end of the 30 minutes, please do feel free to put them in the chat and we'll do our best to answer them. So just a quick intro. I am Felicity, everyone calls me Flick. I'm a partner based out here in our Silicon Valley office, specializing in European data privacy. And I'm joined today by two fantastic colleagues. We've got Richard Lawn and Mark Linane, both out here helping me advise our US clients on lots of these data transfer issues. So really excited for today's topic. I think it's going to be a great one. We've got lots of interesting content. So I'm going to ask Richard to kick things off and give us a bit of a timeline as to how we've reached or got to the point where we've got this Austrian DPA decision. So Richard, what's the background to this? Take us back to 2020. I realise lots of us don't want to be taken back to 2020, but this is pretty much where it all started. So take us back there, Richard.
Yeah, absolutely. Thanks, Flick. Now, 2020 was definitely not a good year for many reasons. And if you cast your minds back, it was in July that we had the Schrems II decision. That was the big landmark case that sent shockwaves through the privacy community, invalidating Privacy Shield, and also setting the scene for this current compliance requirement about use of the SCCs and supplementary measures. Now, there have been a few twists and turns since then and some important developments. So just a month after that decision, in August 2020, NOYB, that's the privacy activist group headed up by Max Schrems, they filed 101 model complaints around EU to US transfers. And specifically, those complaints were directed at EU controllers, websites and platforms that use Google and Facebook services, and the complaints were dropped in a number of different countries, 30 I think in total, predominantly Austria, which is where Max Schrems is from, but also countries like Belgium, France, Italy, and elsewhere. Then, we saw a little bit of a quiet period, actually. We didn't see that much enforcement or kickback from Schrems II in the subsequent months. And it wasn't until March 2021 that we really had our first proper decision since Schrems II. And if you recall, that was from the Bavarian DPA, and it was around the use of MailChimp by a German website. And they essentially held that the website had failed to conduct a TIA. And then a month later, in April, we had another decision based around Schrems II, and that was this time from the Portuguese DPA, and that was around the use of Cloudflare. And that one, the Portuguese DPA went further because here it held that, in fact, there were insufficient supplementary measures, and therefore it ordered a suspension of that transfer of the data to Cloudflare in the US. Fast forward a little bit, so now in June 2021, I don't know if people were having a better summer at that point in time. I can't even tell the difference at this point, to be honest with you, it's all blending into one. But in June, we had the issuance of the new SCCs, which was very exciting, obviously, and we had the final version of the EDPB's recommendations on supplementary measures, which sets out that 6-step approach to conducting your TIAs. Now, then we saw perhaps the start of what is an uptick in decisions following Schrems II. So in September, we had one decision from the Italian DPA about the use of Respondus, which is a proctoring software service in the US by an Italian university. And the decision touched on a number of different areas of the GDPR. Transfers was just one part of the decision. But it found there that, again, the Italian university had failed to carry out a TIA, and therefore the transfer of data to the proctoring service in the US wasn't lawful. And then we've included a decision in December, quite recent on this slide, and that was out of Germany from the Administrative Court of Wiesbaden. And we'll talk about this one a little bit more later, but essentially here, it was around the use of the consent management platform Cookiebot by a German website. And there, it was pretty straightforward in its face, because the court held that the website operator had failed to put in SCCs to cover the transfer of data. But there is a twist in that here the data was actually stored in the EU. It wasn't stored in the US. But notwithstanding that, the fact that the hosting provider was US-based Akamai, the court felt, well, that meant there's still a transfer for the purposes of the GDPR. So a pretty interesting decision there. And then that brings us up to the present day. So January 2022, we've now got this decision from the Austrian DPA on the use of Google Analytics. And I think it's fair to say that out of all of the decisions since Schrems II, this is the one that's really captured the most attention and is causing the most conversation. Google Analytics is a pretty ubiquitous tool. It's used on more than 27 million websites worldwide, and it could have really deep and important repercussions for a lot of different US services.
And just to add that this decision is coming off the back of those NYOB complaints that were submitted to the various regulators back in August 2020. So, and we will touch upon this in a bit, but this is probably going to be the start of a number of decisions that start to come out of the different European regulators on this question of Google Analytics, because remember those complaints were submitted to around 30 different countries. So it's kind of watch the space to see what happens there. But I think Mark is going to talk us through the key sort of aspects of this decision, and we'll get into the nitty-gritty of what it means in practice for everybody.
Thank you, Flick, and thank you, Richard. So yes, I'm going to provide a brief summary of the Google Analytics decision. As mentioned by Richard, back in 2020 in August is when NOYB filed those 101 complaints. The complaint in question here was when a data subject visited an Austrian company's website, and they were logged into their personal Google account, and the website proactively used Google Analytics to process the data subject's IP address, browser parameters, and other unique online user identifiers, such as their operating system and their screen resolution. The Austrian DPA determined that here the website operator was the controller of the data, with Google the processor, and that the use of Google Analytics involved the collection and subsequent transfer to the United States of the data subject's personal data, namely being the IP address and cookie-related data. The DPA then found that the SCCs, which have been entered into between the website operator and Google as an assumed effective measure of protection, were not adequate in this instance. And their rationale? The Austrian DPA determined that Google was an electronic communication service provider under relevant US statutes, and as such, subject to US surveillance laws, such as FISA 702. Google regularly receives requests from US authorities for access to data, as was revealed by its own transparency report, and the courts determined that their supplementary measures were insufficient. Specifically, they called out how data was not pseudonymous because Google could associate it with a user's Google account, and the website operator hadn't activated IP anonymization. They also determined that encryption was not sufficient because Google had the key and could still access the data in a plain text form. And finally, that it was not clear how contractual and organizational measures address potential access by US authorities. Now, what was the outcome of the decision? At the moment, no fine or penalty has been imposed on either Google or the website operator, but that is being held in reserve. As I understand it, the decision is being moved to the Bavarian DPA.
Yeah, exactly. So it's not a finalized decision yet because the website operator has subsequently merged with a Bavarian company, and therefore the case is effectively being transferred under the jurisdiction of the Bavarian DPA. So what that means is, although we've got this preliminary decision, there might be more to come in terms of whether there's a fine, whether there's any enforcement order, whether there's a suspension order, things like that. So there is a little bit more to come with this particular case.
And we also have to remember that the Bavarian DPA has a history of applying a very conservative approach to analysing points of European data protection law, and they've historically been very sceptical or kind of been very vocal about their scepticism about the ability to lawfully transfer European data to the US. So this is all to say this decision as it stands and where it could go isn't great news at the moment, and more on that in a second.
Since the decision was published, even though there hasn't been full outcome, there have been a slew of reactions. Naturally, Google themselves have published a response. They highlight the very much escalating need for a new accord between the European Commission and the US Department of Commerce to quickly finalize a successor agreement to the Privacy Shield. Other DPA statements have come out as well. The Dutch DPA updated its cookie page to state that use of Google Analytics may soon not be allowed. The Norwegian DPA announced it was joining the Austrian DPA's decision against Google and recommends alternatives to Google Analytics. And finally, the Danish DPA announced it's assessing the Austrian DPA's decision and will consider other DPA decisions relating to NOYB complaints in due course.
Yeah, I mean, it's important to consider that we've got this decision from the Austrian DPA. We don't have decisions yet on the other NOYB complaints, and there are other authorities that are looking into those complaints. But the EDPB did set up a task force that's basically looking at all of the complaints and seeing whether to ensure there's going to be a consistency in terms of approach. So although we've got some signals from other DPAs, I don't think the decision is necessarily indicative of, you know, how things are going to fall in terms of the other complaints.
Yeah, although I think what's interesting about this decision is that we see the Austrian DPA very much interpreting the European, you know, the EDPB guidance that came out last year on data transfers, very much applying that guidance incredibly strictly. And they have, through applying that guidance as strictly as they have, inevitably reached the conclusion that it's impossible to export data from the Europe to the US unless the data is first encrypted in the EU and the encryption key is kept in the EU. So it's a, you know, it's a sort of represents an increasing trend in aggressively and strictly interpreting that guidance that came out of the EDPB, and also, you know, a strict interpretation of the Schrems II decision. And so I guess we'll wait to see if this is a continuing trend, but it's certainly, you know, difficult to reach an alternative conclusion to that reached by the Austrians if you do take that strict interpretation of that guidance.
Yeah, I mean, I think that's a good point, because the Austrian DPA is known as a pretty conservative DPA. It's on the more conservative end of the spectrum. But as you say, you know, when it's considering the facts here and applying the law, it is quite difficult to see how it could have come to a different conclusion. And that's really based on this EDPB recommendations. We've got that, you know, famous or maybe infamous use case 6 as an example in the EDPB recommendations, which basically says if you're transferring data to a provider in the US and the data is being processed in the clear, then it's quite difficult to provide technical measures that get
well, impossible.
US access.
They're saying there's no measures that will suffice in that situation. So, you know, we know that Schrems II basically decided that if you are a US company that's subject to FISA 702 or Executive Order 12333, so some of the now infamous US spying tools, then you are not going to be able to offer an essentially equivalent level of protection unless you can bring into the assessment some other, you know, practical aspects that can show that, you know, you can meet the standard of protection required. And the complicating issue with this Austrian DPA decision is that they've gone and looked at Google's purported supplementary measures. And those are supplementary measures that many US SaaS platforms have kind of presented as measures that they're offering. It's very common to see, you know, people talking about the fact they publish transparency reports, that they are encrypting data in transit and at rest. And, you know, they've got important access controls, they're taking steps to minimize data. These are very common supplementary measures that we see published by companies in an attempt to sort of show that they can offer the right levels of protection. And unfortunately, the Austrians decided that none of that was enough, again, because importantly, Google is subject to these spying tools. The encryption key is not held in Europe, and you know, the data minimization features just weren't enough, or in this case, they weren't properly using the IP anonymization functionality that Google offer. So again, just an incredibly high bar is being applied here.
Yeah, absolutely. And not only did the Austrian DPA say, well, I don't see how those supplementary measures are enough, but they did it in one short paragraph. And if you go onto the NOYD website, they've actually got a link to Google's submissions in this particular case, and it's a 27-page letter. It includes a lot of technical detail about how Google Analytics works, but it also includes a pretty long section about all of its supplementary measures. And like you say, Flick, I think actually it kind of looks like the model that a lot of US providers are currently adopting around how they present their measures and the kind of hit list that they're trying to achieve. It talks about, you know, the fact that Google's got a very robust policy and approach around government requests. It publishes transparency reports. It encrypts data in transit and at rest. It also implements other security protocols like access controls. It has ISO 27001 certification. You know, it lists all of these measures, and some of those speak directly to the EDPB's recommendations. And yet, in one short paragraph, this Austrian DPA has said, we don't see how that defeats US government access in this particular case, and therefore they're not sufficient. So, you know, it's definitely, I think, quite a surprising decision in some respects, the fact that Google's position has been given such a short shrift, shall we say. But you know, one question is really, would we have a different outcome maybe if there were different facts and maybe if there was a different regulator? So, for instance, in this particular case, IP anonymization wasn't activated. Would that have made
And is
a
it worth just explaining to everyone what that IP anonymization functionality is? And I can probably take this one just quickly. So Google Analytics, one of the key kind of data minimizing features that they offer is this ability to anonymize, well, they say anonymize the IP. I think if we're being really strict about it, it's probably a pseudonymization technique. But that's essentially the ability to sort of, what they will do is they'll kind of remove the last octet of the IP address. And that typically happens after the data has been transferred, but before it's written down and stored to the within their database. So that was kind of, you know, is kind of seen as an attempt to minimize the amount of personal data that Google Analytics is offering. Now, interestingly, in the Austrian DPA decision, they didn't look into the question of whether or not that IP anonymization feature is enough, but they certainly flagged that it hadn't been properly implemented in this particular scenario, sort of hinting at it wouldn't get you out of an adverse decision from a regulator of, you know, if you can show you've turned the IP anonymization feature on, but it's certainly better to ensure you have turned that on and are using it properly than not.
Absolutely. And, you know, that IP address played a pretty important role, I think, in the decision, not only because they said, well, this is personal data, and therefore that's one of the aspects of the data that helps to ensure this is personal data we're talking about, and you can identify the user, but also because they said, well, in fact, IP address is the kind of data that US surveillance agencies actually use to monitor individuals. So not only was it relevant to that discussion around whether there's a personal data transfer, but also around the risks of access. And actually, I think that brings us onto another point here, which what's, I think, slightly surprising from the decision is a bit of a lack of focus around the practical risks. So it was really looking at the theoretical risks of access by US authorities, but the DPA didn't spend so much time thinking about, but what are the practical risks here based on the type of data and also the likelihood of access. So in Google's press release, they pointed out that in over 15 years of Google Analytics being offered, they've never received a FISA request relating to Google Analytics data. And again, that's the kind of point that most providers are relying on or hoping to rely on at this point in time to say, look, we don't we're not subject to these requests. We never received one, and therefore the practical risks are pretty low. But the DPA didn't spend a lot of time thinking about that or focusing on it. It was really pretty strict in its application of Schrems II and just looking at theory and theoretical possibilities.
And so we're really looking at a scenario where the stricter of the European DPAs simply believe that EU data should only ever be processed in the EU by EU companies. Is that that is the dramatic conclusion we have to reach?
It is a dramatic conclusion, and in our invitation for this webinar, we said, "Has Europe gone mad?" And that's obviously an inflammatory statement, but I think there's something behind that, because, and not to get on too much of a soapbox, but I think underpinning all EU law is this principle of proportionality, and are decisions like this actually proportionate, both in terms of what the GDPR principles say, and this is a principle-based piece of legislation, and the protections for individuals. And in fact, there have been a number of decisions in the past around data protection which have considered proportionality more closely. So the Bayer decision from the CJEU, which was the case about whether a dynamic IP address constitutes personal data or not, that case specifically referred to the principle of proportionality in making that interpretation. And there was another case, Digital Rights Ireland, and that went even further. There, the CJEU found that the EU legislature had actually gone too far and had taken a disproportionate approach in implementing a directive that required telecoms basically to retain certain data. So I think there's a big broader issue here in that, is the law effectively too strict, and are these DPAs being too strict in applying the law?
Well, actually, and that leads to an interesting point, is the law itself does not ban, and let's be clear about this, there is no absolute ban on transfers of European data to the US. That is not something that the GDPR says, and it's not something that the Schrems II decision concluded. And also, if you look at the European Data Protection Board guidance on data transfers, it was very, very clear that there is the ability, and everybody should be doing these kind of assessments on a case-by-case basis to determine whether or not the particular transfer in that scenario can be done lawfully, i.e. whether the recipient can offer an essentially equivalent level of protection, and importantly, provision for the ability to take into account certain practical aspects of that recipient's compliance. And I think what we're seeing with some of these decisions is a bit of losing sight of some of the ability, or at least the analysis of some of those supplementary measures, and has not been done, I think, effectively. So we'll wait to kind of see. I think also the Schrems II decision boxed a lot of the regulators into a corner, because again, if you look at some of that, the strict interpretation of it, the conclusion that it's very difficult to transfer data to the US compliantly is hard to avoid. And also they're under the pressure from the European Commission, who have very much called the regulators to arms and said, we want to see more active enforcement from you, otherwise we're going to step in and start to, call everyone to order here. So they've got a bit of a, they're under the thumb here and under pressure to show that they are actively looking into these issues.
Yeah, and I think, there's we should also strike a slightly different note too, which is picking up on your point that it's a case-by-case analysis. There have been some decisions in the past 18 months indicating that in some cases supplementary measures may be enough. So I just want to provide as a
give us some positive.
It's
we need it. What's the positive
spin on our US clients? So actually, in March 2021, so almost a year ago, there was a decision out of France by a court there, and it was relating to the use of AWS, and it's specifically a Luxembourg-based subsidiary of AWS that was hosting a website COVID vaccination booking platform, and the data was being stored in France and Germany, and there the court found that there was a risk of access by US authorities, but it said that in this case there were sufficient additional safeguards. And it's interesting to see some of those safeguards. So they refer to the fact that here data was only retained for 3 months and then deleted. AWS had provided very robust commitments around challenging government requests. And then here's another one, and this is pretty crucial. Here, the data was encrypted and the key was not held by AWS, but by a trusted third party in France. And so on that basis, it held that the measures were sufficient and the transfer was lawful. So I think that decision does indicate that under different circumstances, and for instance, you know, if there is encryption and the key is in Europe, then potentially we can have findings that enable these transfers to continue.
But of course, you know, some of those measures are measures that many businesses, US businesses can't commit to. So I guess that leads us naturally onto what are some of the alternatives. And I think I'm down to talk about, you know, the possibility to rely on the Article 49 derogations. So just to remind everyone, the way that European data export laws work is that the starting point is that you can't transfer data to the US unless you're able to implement effectively a legal mechanism. The first being either that the third country or recipient benefits from an adequacy decision. So the Privacy Shield was an adequacy decision. Fortunately, can't rely on that anymore, and the US is not an adequate country, or that you're able to offer one of the appropriate safeguards to protect European data, one of those being the standard contractual clauses. And then if neither of those options is available, then the kind of third last resort is, well, can we rely on some of the derogations to the, you know, requirement to implement some of those lawful mechanisms? And one of those derogations, you know, there's a couple of derogations that are set out in Article 49, but they include that you've got the consent of the data subject, that the transfer is necessary for the performance of a contract with the data subject or a contract performed in the interest of the data subject, or that, you know, it's in the vital interest of the data subject, or in some cases in reliance on your legitimate interests. Now, on paper, it seems like a really attractive option to try and rely on some of those derogations. We know the standard contractual clauses are now incredibly difficult to use because you've also got to layer on these supplementary measures, which many companies, you know, are finding difficult to kind of meet some of those requirements. So it seems like this could be the light at the end of the tunnel. Let's move to use the derogations. Unfortunately, the derogations can only be used in kind of vanishingly narrow circumstances, and that's really emphasised in some of the guidance that's come out from the European Data Protection Board. So for many of those derogations, they cannot be used for routine transfers and should only be used to support kind of ad hoc transfers, and only if that transfer is absolutely necessary, for example, for the performance of the contract with the individual, which wouldn't necessarily apply in lots of circumstances. Consent is really challenging, although it's kind of not subject to this limitation that it can only be used for occasional transfers. The guidance is really clear that consent should only be used on an exceptional basis. And to make consent work, it has to be explicit, which means you've really got to identify very clearly the different countries or locations in which the data will be processed and be very clear about the potential risks to individuals. So if you follow those strict requirements, you're looking at quite a cumbersome consent notice that could look a little bit scary to individuals, and it's got to be very clear that it's only applying to a particular transfer or location.
And that's particularly difficult to achieve in the context of, you know, a website implementing a tool like Google Analytics. It's the use of cookies and tracking technologies.
Yeah.
And we know that you're going to be implementing a cookie banner there. There's the e-privacy aspects of consent. And now to layer on this additional transfer-related consent, I think the mind boggles a little bit as to how you can achieve that validly.
Yeah, but I do think it's interesting because I think in the absence of like very limited, you know, we're left with very few other options at this point. So I think you could see lots of companies desperately trying to use consent, particularly in the context of kind of the use of tracking technology. So you could see consent start to be weaved into those cookie consent banners. Now, whether or not, you know, that approach is going to meet the expectations of the regulators, probably not. We know consent is quite challenging to get and to meet that requirement for it to be explicit, and it's only supposed to be used on an exceptional basis. But it could be a kind of last resort to, or a desperate attempt to try and manage this transfer compliance. And we might start to see, even though we don't think it necessarily passes muster, we might start to see more attempt to kind of leverage that consent derogation.
Yeah, and apart from these derogations, one other topic that people are thinking more about is data residency. So is that a potential option, that we host all of the data in the EU and that therefore we can avoid some of these transfer issues? And data residency, you know, is really a topic that's picked up traction since Schrems II, and a lot of companies are thinking, is this something that we should offer to our European customers? Is it worth investing in data residency? And absolutely, I think, you know, that can be a fantastic piece in this narrative, if you will, the fact that data can be stored in the EU. But there are some limitations, and I think, you know, potential issues here as well. So firstly, you know, it's very difficult to offer 100% localization. So even if you're able to provide EU hosting, do you rely on other sub-processors to provide your service who cannot guarantee EU processing and might need to transfer and process that data outside of the EU? And then also, in terms of offering your service, are you also required to access that data outside of the EU for other purposes? Like, do you need to access the data from the US for support services or for DevOps or to run analytics? So I think, you know, importantly, even if you're offering EU hosting, you have to think about those limitations, and that really plays into managing customer expectations and the assurances and guarantees you're providing to your customers. But there's also a kind of a potential bigger issue here, which is a legal point, and that's that there are indications that some courts or regulators would consider that any hosting by a US provider could still be subject to the transfer provisions of the GDPR, even if the data is physically localized and hosted in the EU. And I'll just take a minute to point out a couple of decisions on that question. So we had a decision out of France in October 2020, and that was relating to the hosting of France's health data hub by an EU subsidiary of Microsoft. And in that case, the CNIL actually submitted comments during the proceedings and said that even though here it's an EU subsidiary, and even though the data is stored in the EU, the fact that Microsoft is ultimately subject to US laws means that Schrems II should apply, and therefore the processing is incompatible with the judgment. Now, in this case, the court didn't agree with that, and they said actually Schrems II doesn't ban or prohibit the use of US service providers, and therefore they didn't choose to suspend the processing. But despite that, after the decision, France's Secretary of State for Digital Affairs announced that they would be migrating the hosting of the health data hub to a French or other European provider. So, you know, even
enough to scare them.
There was enough to scare them in that case. And then actually in December, so just a month ago, we had another decision that went further here, and that was the decision from Germany, a court in Wiesbaden, which I referred to earlier. And here, it was around a website's use of cookie bots, and a cookie bot relied on the US-based hosting provider Akamai to host some of the data. But again, in this case, the data was actually hosted in the EU. So, you know, the actual judgment was around the fact that the website hadn't implemented SCCs, there wasn't a transfer mechanism, so, you know, fairly uncontroversial there. But the interesting point and the twist is that the data, again, was in the EU, and the court held that that means there was a transfer for the purposes of the GDPR.
Well, there was still a transfer, yeah, and it was really the fact that Akamai is a US company that they had real issue with. So notwithstanding the data was stored in Europe, the fact that it was accessible to Akamai, a US service provider, to Cookiebot was enough to, you know, create an issue there.
Yeah, but again, in both of those decisions, it's important to point out that the courts weren't ruling that the use of providers like Microsoft and Akamai are illegal per se. That's not what they were saying, but they were saying that there's potentially a transfer of data there, even where you were relying on data residency. So just to flag that, you know, it might not be the silver bullet in terms of addressing some of these Schrems II requirements.
Yeah, if you're a US company, you know, I think that you're always going to be open to the criticism that, you know, even though the data is stored in Europe, it's still within the scope of those US spying tools, which are causing so much anxiety on the part of the European regulators. So I guess that leads to, what about Privacy Shield 2.0? Is that going to come and save the day?
Yeah, this is what everyone's pinning their hopes on, I think, at this stage.
Yeah, certainly Google Analytics is, and you can see that in their desperate plea in their response to, you know, come on Europe, come on US, can we agree some political, you know, solution here? I think we would all be, you know, we've had people ask, you know, do we think the US is going to, you know, make any legislative changes to come and save the day? I think we've got to be realistic and expect that Congress is not going to move quickly, if at all, given the lack of, you know, I guess they don't have any, they've not stated any public desire to make changes to their spying tools, as I like to call them. So I don't think we should expect that there's going to be any legislative changes coming through Congress to come and save the day. So we're really looking at alternative measures, and I think it is going to be, you know, Privacy Shield 2.0 is probably going to be the only big political agreement we can expect to come and help in this scenario.
Yeah, and we haven't had any formal announcements recently on how far they've got with those discussions. Last year, we heard a few statements saying that talks were ongoing, that they were intensifying, but nothing recently. And I think we probably, and this is just my view, I think probably we will see a big acceleration now this year and potentially some more progress there. In particular, now following this Google case by the Austrian DPA, and that's really going to be flagging to big tech. Who are really going to push hard that we need some movement here, we need some decisions.
But of course, the big issue there is, can, you know, the negotiations, the centre of those negotiations, the big issue in the room there is, can the US offer, or can that Privacy Shield scheme offer effective redress for individuals? And that's going to be the thorny issue, and I don't think Europe's going to give up on that point, because that's central to the Schrems decision.
So thank you for those light dive into the alternatives. What else can we expect in 2022?
Well, I think the first thing that we can expect is that this decision by the Austrian DPA is just the first following those 101 model
buckle
complaints. So buckle up, because we will see more decisions coming through, and some are thinking this is maybe the first in the domino of decisions about the use of Google Analytics, and also relating to Facebook as well. So yeah, more decisions are on their way.
Yeah, and I think maybe we should go on quickly because we're running out of time. Maybe we should have a think about some practical. And sorry for running over, guys. There's so much to talk about here. But so as you're kind of looking ahead to what on earth do we do if you're a US SaaS platform trying to figure out what you tell your customers, or, you know, how you kind of prepare for some of the year ahead, I think, you know, there is no silver bullet here, and unfortunately there's no perfect compliance solution that people can offer. So for most businesses, it's simply going to be a case of hopefully business as usual, hoping that they don't get on the radar of any EU regulator or civil organisation like Know Your Own Business. But there are some things that you can be proactively doing. You know, I think making sure that you've understood your data transfers and completed those transfer impact assessments is going to be a key thing on your to-do list for this year. Many of those decisions that came out of last year were actually focused on the lack of transfer impact assessments having been completed. Now, we have to remember that most of those decisions were actually enforced against the data exporters. So if you're a US SaaS platform, your European customers, you know, no data importer, as far as I'm aware, has yet been done for not having helped with the transfer impact assessment. But knowing that your customers are going to be under increasing pressure to make sure they've done those impact assessments, you know, you can help those customers by perhaps preparing your own customer facing information pack or transfer impact assessment to help them with that task. And to help get over that hurdle, because they're going to be very concerned about that, and it's a huge task for your customers to be doing. So how can you help them do that? And if you are a data exporter, obviously that's a crucial, you know, you bear the primary responsibility for doing that transfer impact assessment, so making sure you're doing that is important. If you're using Google Analytics, it's perhaps worth thinking, how much value are we getting from the data that we're getting from Google Analytics? I know that many SaaS platforms rely heavily on Google Analytics to collect useful data for their product development purposes. etc., to know their, how their end users are interacting with the feature. So it's usually a pretty crucial set of data. But making sure that you've done things like turn on that IP anonymization feature, just doing an assessment to check, actually, is it valuable data to us, or could we turn it off? And importantly, if you get customers saying, I don't want you to use Google Analytics, is there a kill switch option that you can offer to turn it off? And then kind of just addressing some of that low-hanging fruit. So lots of the privacy activism at the moment has been targeting, some of that window dressing compliance out there, your cookie banners. Cookie banners have been an increasing source of NYOB focus, for example. They went out and sort of did an active audit of lots of European websites to check whether or not the cookie banner included, for example, in addition to the accept all button, a reject all button. So many websites have taken a bit of a risk-based approach and just offer an accept all and a manage cookies option without offering a reject all button. And I think it's probably something worth re-evaluating as an approach, and just adding that reject all button back in there, because it's so easy for them to pick up on that and then kind of make you the subject of a complaint.
It's like a flag not only for regulators but also for activists. If somebody's looking to complain, they can very easily look at your privacy policy, they can look at your cookie banner, how that's implemented, and they can pick up on some of those points. So there's some low-hanging fruit that can be addressed to just basically ensure that you're not giving exposure there on what could be potential flags.
The other thing is you mentioned privacy policies. I think there's going to be greater scrutiny of the transparency you provide in the privacy policy. There are some legislative changes this year. I know that Switzerland's updating its data protection law to include an obligation to provide more detailed transparency around data transfers. So I think making sure that you've covered off some of those requirements is a good thing. And then I think one important thing is we're not quite sure what's going to happen over the next year, but we know it's going to be rocky in terms of some of the decisions that might come out. So I think it's important to prep your board just so that you've let them know that this could potentially go and impact some of the European sales pipeline, or to start to creatively think about how you could, re-engineer some of the way that your data architecture is set up. Could you offer European hosting? Is that something the business is willing to commit to? Could you spin up a European entity and perhaps start to contract through that? So having some of these discussions to at least get your board ready for some of the potential, impact of the emerging decisions that could come out over the next year.
And last on that list, we have don't panic. And we say this almost every webinar we do, but really don't panic, because this is one decision against a provider, and 2022 might yet be the year of the transfers, but we're hoping for more guidance, we're hoping for more consistency in decision making, and we're also hoping for potentially a more practical interpretation of Schrems II and some of these decisions. So there is not necessarily a need to panic just yet. There's still going to be a lot of discussion and potential movement on this topic.
Just be ready, just start to build your compliance story, and ultimately it's really on the data exporters. Most of you listening will be US SaaS platforms. It's ultimately on your customers to come to a decision about your compliance, and the best you can do is just arm them with as much information and layers to your compliance story as you can reasonably present to try and get them comfortable with it.
So we've got a few questions. Thank you so much.
Oh my goodness, some really
quite
good
a few. We're probably not going to have time to go through all of them. A very quick one to start off, though. Can you tell us about the new UK SECs? Any information you might have on those?
Fantastic question. So as some of you on the call might have been aware, the UK had not previously formally adopted the new European standard contractual clauses that were published last year by the European Commission, and post-Brexit has been trying to flex its muscle and had been consulting on its own data transfer agreement. And actually that data transfer agreement looked very different to the the new clauses. But there was this kind of also in the consultation, there was this addendum that they were also consulting on, and that would be an addendum that would be added to the new European standard contractual clauses, effectively allowing UK companies or data exporters to use the EU standard contractual clauses, provided that they added on a kind of UK approved addendum, which effectively acted to localize the European clauses so that they worked for the UK. So when it said GDPR, what we really mean is UK data protection law, etc. And that consultation has now ended. The ICO has kind of formally published its kind of final drafts of that data transfer agreement and the addendum, which are now before the UK Parliament. So provided that there's no further issues raised, that addendum and the new UK data transfer agreement should be something that people can use moving forward. Interestingly, they've baked in there a very generous transitional period. So they've kind of said anybody using the old standard contractual clauses for contracts before that were executed prior to September 2021. It actually said, I think incorrectly, September 2020 in the document that was put forward to the UK Parliament, but I think that we can assume that was a typo. But if contracts entered into before September last year could continue to use the old European clauses up until, I think it's March 2024, so that's a pretty generous period. But effectively, if you're trying to kind of manage UK transfers and you want to have a kind of one size fits all, use the European clauses plus the UK addendum, and that should work.
Okay. So we've got a couple of questions regarding FISA 702. One was, if Google were not subject to it, would the outcome have been different? And a similar one is, what are our thoughts regarding organizations that are unlikely to meet that definition?
I think those are great questions. And definitely in these decisions that are coming out and in the Google Analytics decision, it was pretty fundamental that the provider here, Google, qualified as an ECSP under Section 702 FISA and therefore was subject to US surveillance laws. And really that does come down to the Schrems II decision. That was the law that was the focus of the decision. That's the law that was deemed to interfere with data subjects' rights under EU law, and therefore the protection wouldn't be sufficient. So it's quite fundamental here that Google qualifies as an ECSP, and they didn't go into a huge amount of analysis as to why that's the case. I don't think it's a point that Google itself would dispute, but we haven't seen yet any cases where a provider has disputed that and said, in fact, we're not subject to the law, we don't qualify as an ECSP. So we haven't yet seen kind of a tussle on whether that factor could potentially sway a decision another way, and a court would say, well, or DPA would say, well, actually, we agree you're not subject to FISA, and therefore some of these considerations mean the transfer can take place. I
think it would be incredibly persuasive, in my personal opinion. The fact if you can show that you're not actually subject to some of these law enforcement, or surveillance laws, then that really was the nub of the concern in the Schrems case. It remains the key area of concern and focus in the Austrian DPA decision. So to me, that if you could show and evidence through appropriate analysis that you fall outside the scope of those laws, to me that could be incredibly persuasive in showing that actually you are able to offer an essentially equivalent level of protection using the SDCs and potentially just a smattering of other supplementary measures.
Thank you, Flick. Thank you to Steph for noting the ICO have noted today that they're aware of the transitional provision documents incorrectly referencing 21st of September 2021, and their teams are looking into it. Another question though, do we have any insights on the German case and the use of Google fonts?
Yeah, so I mean, the Austrian DPA decision is getting a lot of attention, but there have been a couple of other Google-related decisions this month. So we also had a decision from the EDPS, the European Data Protection Supervisor, and that was around Google Analytics 2. And then just hot off the press in the last few days, we also had a decision about the use of Google fonts. And this decision was pretty similar, to be honest with you. It basically said that there was a transfer of personal data involved by the use of Google fonts, and there were not adequate measures to support that transfer. So I think there are some other decisions here that are reflecting, mirroring the Austrian DPA decision, and as we said earlier, we're going to see more to come. But again, it's the Austrian DPA, the one that's capturing the most attention.
And just to kind of, I think, just to pick up on a couple of other themes and some of the questions, a lot of you there rightly getting frustrated by the fact that, you know, the Austrian DPAs think that truncated IP addresses are still personal data. I totally get that concern. You know, the chances of that truncated IP address being able to single out an individual at that point, I guess, is the big question. I think one of the big issues that they had was that there was still the ability for Google to link some of that data to other data that they had on their systems to create more of a profile about the individual. So, for example, if somebody was actually logged into their Google account, went to visit a website, and the IP address was collected, I think there was still some concern that even if it had been pseudonymized, that it would still could be connected with other data that they would have about individuals. And I think that was causing some of the concern.
Yeah, I mean, let's not forget that in this particular case, IP anonymization hadn't been activated. The website operator had failed to set that up correctly. I think it was a technical oversight. They had intended to, but they hadn't. So in this case, I wonder whether if they had activated it and implemented it correctly, could that potentially have made a difference as to that analysis around whether the IP address was personal data.
And the other issue was that the way that the IP anonymization works is it only happens after the transfer has happened, which I think is another issue here.
We've got another interesting question here about, are we seeing a trend toward data localization versus data sovereignty? And I think that's, you know, a very interesting question. Let's not forget that it's not only the GDPR that's focusing on data transfers and pushing towards potential data localization in the future. There are other laws as well that are introducing similar restrictions around transfers. So we have in China the new personal information protection law and security standards that are looking to impose limitations on transfers of data outside of China. We have other jurisdictions considering similar laws. And I think, you know, that does indicate that there is a little bit of a push towards keeping data within boundaries and being skeptical of the cross-border transfer of personal data into other sovereign territories. You know, and it's in a way it's not reflective of our times, because as we know, the internet is borderless, and so it doesn't seem necessarily sustainable. The law is in tension there with how the modern world operates, and it raises a lot of doubts over, I think, the future of how services are going to be provided.
And I think this whole issue of surveillance laws is just being heavily weaponized here, and obviously there is, you know, we do need to worry about some of these surveillance laws, but I think it's interesting that Europe has become so focused on the US spying tools. We have to remember that it too has its own surveillance laws, and they're pretty aggressive as well. So I wonder if at some point the US might turn around and say, hey, what about US citizens that you're spying on?
Yeah, I mean, a lot of this is political at the end of the day. I think there was a lot of politics behind the Schrems II decision and where all of this is leading to. So, you know, law is stuck in the middle and providers are stuck in the middle to an extent, but this is really an issue around surveillance in different countries. And potentially the only way really out of it is to seek a political solution to what is a political issue.
Yeah. And Steph, thank you for your offer to provide a free webinar to us about how Google Analytics sends more data points. I'm definitely interested to hear more about what you have to say, so feel free to reach out to us afterwards. Cool.
Thank you so much, everyone, for joining us today. Apologies again, we've run over slightly, but some excellent questions coming in. We would love to see you again. We do have a new webinar series coming up, starting on Wednesday, the 16th of February, looking at vendor and contract management. And that'll be an ongoing series that will run 4 or 5 sessions. And we'd love to see you there. The recording of this session and all those future sessions are available on our YouTube channel, and the link is there too.
And sorry we couldn't answer all your questions, but thank you for submitting such interesting ones.
Thank you very much, everybody.